Hello, I'm Ai Makaraig. Welcome to Talk Thursday. This week, the president stirred controversy after two major speeches where he defended the government's Disbursement Acceleration Program or DAP despite a Supreme Court decision declaring key acts under the program unconstitutional. How should we view the president's pronouncements and the High Court ruling? Joining us is Dean Tony Lavinia of the Ateneo School of Government and a thought leader of Rappler. Hi, Dean Tony. Welcome back to Rappler.
Thank you. Hi, how are you?
Good. This week, you had a column. You wrote about what you call the war of the branches. And it's interesting because in the president's Monday night address, he said, to quote, "My message to the Supreme Court, we do not want two equal branches of government to go head-to-head, needing a third branch to step in to intervene." So how do you interpret that message, and what do you think are the repercussions?
Well, I was bothered by that statement because the only interpretation you can make about a third branch intervening is the extreme action of impeachment, right? Because he's talking about Congress. That's the third branch of government. It could also mean investigations like the Judicial Development Fund, etc. But I think here clearly he was signaling about impeachment. When I actually wrote the column, "The War of the Branches," I wasn't talking about the president. I was talking more about other politicians saying that it was time to look also at the Supreme Court, and I was warning that we shouldn't really go there. Nobody wants to go there. But when the president made that speech, it raised the stakes. I mean, the implications are enormous. But I have to say that the next day, because you said two speeches, the next day he gave a speech with the World Bank head there in the Department of Budget and Management. I thought that was a more circumspect speech. That warning was still there, but first he made it clear that he was doing this because it was his right to file a motion for reconsideration, and that's fair. And he was doing this also very clearly, according to the president, while obeying the Supreme Court. That he had actually, out of prudence, ordered everyone to obey the Supreme Court decision. That's a big thing, because he's definitely not defying the court.
So at least that clarified the intention of the president. Let's go further down to the speech, because it was a speech a bit full of indirect statements. You don't really know what he means, and people were left guessing with different interpretations. So the next thing he said was, addressing the Supreme Court, "You had done something similar in the past and you tried to do it again." And then to summarize what he was saying is, how come when it's the executive that's doing this, you're saying we are wrong? What does that mean?
Yeah. No, I mean, I think I think those two things are different, though. I mean, the first thing about you've done something in the past, you're doing something again, I think that really refers to part of the decision regarding the statement on liability, which is a non-binding, which you call it an obiter. It has no value at all, no legal value, but it could be used politically, and groups against the president have used it politically. This is where the opinion says that while the doctrine of operative facts apply to those that have implemented the acts, those that have to the acts itself, right? The fruits of the unconstitutional act, it does not apply to the implementers unless they show good faith. That's actually a very bad statement in the Supreme Court's decision, because it flipped the presumption of innocence, the presumption of regularity, the presumption of good faith. And when you read that decision, that part of the decision seemed to have been inserted. So my view, and I don't know the mind of the president here. Honestly, I don't know anyone in Malacanang in terms of that did that speech. But when I look at that, I think that's the particular statement that's problematic from the point of view of the president. And it's been done in the past. And we sort of recall that in the time of the President Arroyo, when the Supreme Court issued, this is a Corona Court, issued the TRO against the hold order of President Arroyo, and Justice De Lima was supposedly defied that. It was on the basis, actually, Justice De Lima, Secretary De Lima would say, I did that because the requirements of the TRO has not yet been fulfilled. And there was discussion apparently in the end bank that certain requirements have to be fulfilled. But in the course of issuing the TRO, that those requirements disappeared or were changed, and Justice Sereno, actually complained about it publicly. And so maybe the president was referring that something was done in this decision. I don't know. But I think it's best for the Supreme Court to clarify, very clearly that this is not part of the decision, that this is just an obiter, and many of the justices actually do not subscribe to it. Because it's not fair to make a judgment about good faith, bad faith, liability. No facts at all to make that determination.
And they say the Supreme Court is not a trier of facts anyway.
Yes, that needs to go to charges filed, to trial, to have really facts before any kind of pronouncement on liability. So I don't even consider that guidance for the people. I mean guidance for lower courts at all.
But let's elaborate on that point of liability, because as you mentioned, some groups are now raising this and even filing cases against the President, Budget Secretary Abad. Can you elaborate on the operative fact doctrine? And some people are saying that administration officials might be liable for technical malversation.
Again, those are two different things, and the decision actually confuses that. That's why I think the president is mad. Also because it's also applying a different standard to the executive. I think that's the whole point. There's supposed to be a presumption of good faith, presumption of regularity of functions, right? And we apply that to the judiciary, to the legislature, to the executive branch. Now, in this particular case, what happened was the doctrine of operatives definitely applies to projects and activities, right?
Okay.
It simply means that if a project was done under DAP, delivered, then it's over and it's recognized. There's no need to, you don't tear down the building just because it was built by DAP. You don't not pay the contractor just because the funds used were from DAP. You have to do all of that. That's where the doctrine of operative facts stop. It doesn't have anything to do with good faith, bad faith, liability.
It's just that
it's just a recognition. Well, it's just a recognition that there are fruits of unconstitutional acts and they are to be respected. Period. Right. Liability is entirely another thing. And you're not supposed to talk about liability here. And if you talk about it, then you start with presumption of innocence. And then you start with presumption of good faith. And then presumption of regularity. All of that you have to grant to government officials, you have to grant to courts, you have to grant to the legislature. Otherwise, if you start with presumption of bad faith, that's problematic, I think. And I think all the concurring opinions actually say that, including Justice Brion's opinion actually says we have no finding of facts here about liability. There's some speculation about, well, they're congressmen, etc.
Yes, they should have known better.
Yes, but that's exactly, you should have known. I mean, it's all speculation and all, from my point of view, not legally meaningful.
Going back to the president's speech, he is insisting on the legality of DAP and citing the administrative code as the legal basis. But following that, some legal experts, you have Father Bernas saying that the admin code antedates the Constitution and it really should not supersede the Constitution. So what's your view on that? Why are we still debating the legality of DAP?
Well, because I think the administration has to do that, and because they need to make their case better, probably. My understanding is they didn't really actually make this case before the court in its pleadings, in its oral arguments. I certainly don't recall that this is particularly the particular provisions. Article 49 was made. I think they made it on the basis of Article 39. Now, actually, Father Bernas is wrong in terms of the dates. Just to be sure about that, and we've clarified that a number of times already, a number of us. The administrative code was issued after the 1987 Constitution took effect, because the 1987 Constitution took effect in February of 1987, the administrative code in July. President, just historical trivia here. President Aquino kept her legislative powers until July, because that's only when Congress met for the first time. So that's why even if it was a constitution already took effect, she could issue an executive order. Now, having said that, and I actually work in the administrative code. I'm so proud because I was a second-year law student and legal researcher at that time for Professor Papo Lutilia. And the administrative code, we wrote that in the UP Law Center with the Constitution in mind. We would not have written anything unconstitutional in that, So the only way you can interpret Article 39, Article 49, Article 34, Article 49 is in light with the Constitution, not in the way that they are citing it to support DAP, right? So that for me, in that sense, that argument holds no water at all. If that's the main argument.
Defense.
No? Now, of course, I must say this. The justices here, the Supreme Court, did a very strict reading of the Constitution, what I call to the letter reading of the Constitution of Section 25. Another Supreme Court that were, less strict constructionists might have another reading. But under our system, we have one Supreme Court. That Supreme Court interprets the law, and it's the final word on the law. You can file a motion for reconsideration, which I think is fine, and it's good in this case to clarify certain things. But once the Supreme Court decides its motion for reconsideration, we really have to obey. Look at the consequences. If the president says, "I will not obey," I will not, which he has not. But the consequences is down the road, right? If the electricity companies, for example, if the Supreme Court ruled against them, they would say, "No, we will not obey."
Because the president did not obey.
Yeah, if a politician is ousted from his post, let's say out of a disqualification, "No, I will not obey." If a governor, like what was done to Governor Hercito, it was ousted by the Commonwealth, "No, I will not obey because I'm right." We'll have chaos in this country.
Okay. Just a question from one of our Twitter followers, going back to liability. Why do you think the SC mentioned it at all if you presume good faith? Like, if we're not going to try facts and we assume good faith, why did it had to dabble into that issue?
I've read thousands of Supreme Court decisions. Unfortunately, in the Philippines, we're fond of writing things, including things that are really not part of the decision. So different. And my colleagues in the Supreme Court, my elders, I would call them, the people we look up to, forgive me for this comment, but in the U.S., decisions are very spare, right? They just go decide the issues that have to be decided. So here, it's one paragraph, right? At the end. It was important to do the doctrine of operative facts. That's important because it's important guidance to the government, to the executive branch. What to do with projects supported by DAP. So that's important. But the doctrine of operative fact has nothing to do with liability. So they should just have stayed away from that and wait for, as I said, the right proceedings for liability. Which, if you ask, as you asked me earlier, plunder is certainly not the right case here. I mean, there's no case for plunder. Nobody's saying that the President or Secretary Abad has benefited from any of this. I mean, on the contrary, there's more evidence that the DAP has done well for the people and good for the people. But there could be technical malversation. I mean, charges. I'm not saying, there's no facts at all for that. Also, right now, there's no basis for that. But conceivably, if there's basis for that, that would be the case, and that would be the charge. And their good faith actually doesn't even matter there. I mean, it's a question of public funds and how they were used. I mean, and the fact that they were constitutional at the time they were used matters a lot. Because unconstitutionality happens after. You know what I mean? And so the doctrine of operative facts is related in that sense, but it's not. It's an entirely different thing, and different set of facts have to be proven.
In the World Bank speech, the president warned that the decision might create a state of paralysis for the government. He was arguing that we needed DAP to accelerate spending because address underspending, and some people are now arguing that the ruling might tie the hands of the executive in funding projects and pump priming the economy. Was the Supreme Court cognizant of that? Although you say you make a distinction between law and governance. Like, what are these two issues that maybe people are also confused?
And I borrowed the distinction from Professor Randy David, just to be sure. I mean, in governance, you have to stretch the limits of the law because you have to solve problems directly. And another colleague of mine, Dean Mel Santamaria, pointed out very well that ultimately the president is responsible for this country. It's not the Supreme Court. It's not the legislature. So therefore, you have to give the president wide latitude.
Right.
But you cannot never give the president unrestricted latitude, right? Because if you do that, that's a dictatorship, and we end up like with Marcos, right? I mean, that's what we end up with. So you give him wide latitude to innovate, to solve problems, but with always these boundaries. And who sets those boundaries? It has to be the Supreme Court. That's law. So governance is expanding those boundaries, stretching it, and law is actually telling you you've stretched it enough. This is it.
These are the limits.
Yes. Now look, I don't buy the argument that the loss of the DAP will lead to paralysis, because the DAP no longer exists.
Right.
They in fact terminated it last year. They said that it's no longer needed. In the future, for emergencies, now you know. For emergencies, you have to pass special budgetary acts, special appropriations. You can do it fast, I think. If it's I think within a month you can pass a special appropriation if there's political will to do so, especially if you have a majority like the president has in both houses of Congress. So again, that's not an excuse. And finally, and this is what puzzled me in the speech of the president, he said that he can no longer use savings until the end of the year, when it can no longer be. That's
December
not true.
31.
That's not true. Every month, government has savings. Every month, every agency has savings. Those savings can actually be pooled. Those savings can actually be used, but only to augment existing items.
And those in the same department.
Yes, but there's really no way around that, no? Because then if the president is the one that chooses what to spend and where to spend, then you're no longer a presidential system. You're a parliamentary system of government. Kaya when I was listening to the president actually, and I didn't catch this attack on the Supreme Court right away because it was kind of nuanced, I mean, until you actually saw it in writing. I actually thought the president gave a very strong argument for a parliamentary system of government. Because basically said, the problems of the country are numerous. There's so many. I want to solve them, and I'm in good faith in trying to solve them. And I need the money, I need the resources to do that. And I need it immediately. I can't wait for Congress every time. In a parliamentary system, you don't have to do that, because your prime minister is also in Congress, is also in the parliament, and you are party in power. And so you can just change the budget anytime, at will. In our system, it's not like that. It's a separation of power. Congress is the one that actually decides what to spend money on. The president spends the money, has flexibility to move money from one item to another, but never add additional items, and never cross-border transfers. I mean, that's plain language. I mean, the administrative code does not authorize that, and nothing authorizes that except practice. And here the president is right. The president the Aquino administration did not invent any of these practices.
Yes, they simply from the past. They
inherited all these practices, put them together into one package, and called them DAP. It was their transparency that in a way caught them with this unconstitutional bind, because they put it into one package and called it something, while putting together practices in the past. So that's again another point. The president, why did you allow that before but not us? I mean, not now. I mean, so there's sort of a hint there that you're putting a different standard on us to make it more difficult for us to govern.
From a Twitter follower, Chito Irigo, is the Supreme Court then unassailable? Must we take their word as done in good faith? No. The Supreme Court, once it made its decision, can be criticized. Okay, should be criticized. That's why I'm criticizing the liability provisions of the liability obiter of the Supreme Court. I mean, right now there's no motion for reconsideration, so technically we can talk about the case, right? I mean, and it's, I think, from a public point of view, it's important to educate the public right now, so we should be able to talk, and this would be, I think, sub judice right now. Yes, we can criticize the Supreme Court, but we do have to comply, because if we don't comply with the Supreme Court,
then who do we comply with, right? For big issues, for these issues. There's a reason why the Supreme Court was given this power by the 1987 Constitution, the power to intervene in these things. It's called the expanded power of judicial review. This was the Marcos experience. If you can guarantee me that we will never have a Marcos again in this country, that our president will always be as good as President Aquino, that our president will always be as sincere, if you can guarantee me that, let's take away that power from a Supreme Court. But if you can't guarantee me that, then we're better off having a Supreme Court that makes mistakes, but is the final arbiter for disputes. Only for disputes. If there were no dispute, the president could do anything that he wants. But there's another group of people in society, including congressmen, including party list representatives, that disputes the president on this. That's why it's a legitimate case. It's an actual case or controversy because of that.
How do you think the administration should move forward? It's filing an MR, President Aquino announced that. But other than that, because they say this should really translate to budgetary reforms, like what should be done?
Well, actually, a lot of it the government has already done. I mean, our Secretary Butch Abad has been very good about budgetary reform and really changing the way we do budgets. The fact that they have budgets on time every year. The fact that they have performance-based budgeting. And I mean, a lot of the problems in the past, hopefully, if it's followed through in the next term, the next president will not happen anymore. I think Congress has a lot to do. Congress needs to be very serious about its role in budgeting. There's even no congressional budget office that really does the budget. I mean, the budget right now is done by the DBM.
Right.
And then given to the committees, to Congress. It should be the DBM working with the Congressional Budget Office. Permanent staff, professional staff, same staff as the DBM, economists, governance specialists, lawyers who will do this. So that's one. I think second, I think the government needs to be forewarned that we have a strict constructionist constitutional court, right?
Okay.
Meaning to a court that will interpret the Constitution to the letter, not just the spirit, but the letter. We're forewarned about that, and therefore we want to be very careful. We want legal reviews. I mean, even of old practices, to be sure that we are covered when they're covered when they make decisions. But I do think that the president can still do quite a lot. I mean, and Congress can still do quite a lot in spite of this strict constructionist Supreme Court that we have. I mean, it's just that it needs to be more based on real, solid, also legal work that has to be done. As for what needs to be done on this specific thing, I think a motion for reconsideration would be good. Good luck on that. I hope when the decision comes out, especially if the court also clarifies the obiter nature of the liability statements there, then I would hope that the president would have the grace to reluctantly accept the decision and move on.
So there's a possibility that the court might clarify after the MR, at least the issue of liability.
No, in the MR itself, in the resolution, they can do that. Or the justices can have concurring opinions. The thing is, I mean, that's why I say, maybe this part was not in the part of the justices, because none of the concurring opinions refer to that part of the main opinion. I was surprised that Justice Leonen, for example, who says we should not be speaking about liability here, does not mention that part of the decision at all in his concurring opinion. So if the court did that, I wouldn't consider that weakness, because if that's a mistake, if they made a mistake, they should acknowledge that they have made a mistake. And that, for me, as far as I'm concerned, that's sort of a clear mistake. And things happen. I mean, Justice Lucas Bersamin is one of the most brilliant justices in the Philippines, and one of the best in terms of procedure. He knows presumption of innocence really, really well. I mean, and so it might have been gotten lost in the sort of the writing and how they were rushing to have it out because media was there. In all of this, maybe that got entangled with the doctrine of operative fact. But if presumption of innocence were, for example, laid down, right, and very clearly, or just not to be silent at all, just to be say, in this part we don't have to mention because it's not right to mention it. I wouldn't consider that the Supreme Court bowing to pressure. I would consider that the Supreme Court doing the right thing.
Okay. Let's talk about politics, because on the same day of the president's address, the reports came out about his survey ratings, that they had gone down at about more or less the same time the decision was released, also coupled with the high prices of goods. What do you think is the impact of this on the Aquino administration, of the decision on DAP, going into its last 2 years?
I think it will, well, I wouldn't say that politics is so fickle, right? I mean, so
right.
I'm not going to predict in the next 2 years what will happen. You know what I mean? But I will predict in the next 6 months what will happen, right? I mean, I think we just started seeing the downtrend because it was only in the last 2 days of the Pulse Asia survey that the DAP came out, and it was not even factored in the SWS survey. Because they ended earlier than the Pulse Asia. So for sure, in the next quarter, this is going to be reflected. Because that next quarter survey will be around August, I think, right? July, August, September. So I think it will be factored in what the president did, the speeches of the president. And what at first seemed to be defiance. Although I would take that back now. I don't think he was necessarily defiant. He was mad. He was angry, but he wasn't necessarily defiant.
Okay.
But if the people saw that as defying the Supreme Court, that could also, I think, be lead. It's very clear here. These are popular decisions. If you're talking about popularity, the DAP decision and the PDAF decisions, people see this as one. They're not the same, and the president is rightly incensed that people would compare DAP to PDAF.
He said, "Excuse me."
Yes, I know, and I agree with him there. I completely agree with the president. But unfortunately, to the media, to you guys, the way you report it, and to the people, not necessarily Rappler for you, but media in general,
might be confused.
It's confused, and it's the one and the same thing. It's corruption, both, right? So that will have an effect. I mean, in the same way that when the president tried at first to defend PDAF, it wasn't tenable to defend it, right?
Right.
So they need to figure out how to, call it jujitsu, how to move this from a political point of view also to an advantage. And the way to do it, actually the president started to do is look to show projects that have been done with PDAF.
To release the list.
That really have made difference. The list, I mean, assuming that it's a good list and there are no problems in that list. The way, I think that's what has to be released to the public.
But some were pointing out, some critics were saying that a part of the DAP was given to lawmakers to augment PDAF. And there are questions on the use, at least for several senators, some of whom also implicated in the PDAF controversy. That doesn't seem to have been settled so far, like whether it was used properly or not.
No. And the executive branch has not taken responsibility for that. I mean, which honestly I find also strange because, like any PDAF funds, as the legislators will tell you, this money was given to agencies that are under the responsibility of the executive branch. They were projects that I identified, and as we know now, implementers were endorsed. There was pressure from the legislators. But these are lodged in executive branch. These were not cross-border transfers. At first I thought, did the Supreme Court mean the money to the senators? No, these are not cross-border because this money was given to the executive agencies. So it's still strange for me that they would say that they will not vouch for how that money was spent. I think it's 9%.
Yes,
9% of the DAP. I mean, and that's strange for me that they would not do that because they need to take also responsibility for all funds that all agencies were were implementing.
The executive branch.
The executive branch were implementing, yeah.
Okay, lastly, let's talk about what do you think this debate means for democratic institutions? Some are warning this might lead to a constitutional crisis after the president's speech. Some say this is healthy for democracy. You see checks and balances. What's your take?
If it's resolved properly, then it would be very healthy, right? If we would say, yay, we made it, and we're now stronger as a democracy, and we have a stronger Supreme Court, actually stronger and better president. The legislature will actually benefit the most from the PDAF and DAP decisions.
Really?
And yes, because they have more power. That's why one of my friends was saying, in government, do you really want that? And my answer is that that's what the Constitution actually says.
Okay. Power of the purse.
Yeah, and also that the power should belong to the people, and the people is represented by the representatives, right? I mean, and so they really are the ironically here. Ironically, because they're also the some of them are the villains, right? I mean, or alleged to be the villains. But the legislatures are actually the most. The legislative branch is actually the one that benefited the most. They have a greater role now in budget making that they never had. They never had before. No, but to get to there, we all the branches of government need to really get their act together, right? I mean, as I said, I mean the Supreme Court also need to do something here. It's not as if they are completely blameless, as one of my Dean Santa Maria also points it out. I mean, it's the language, it's the way they put suddenly the presumption of turned around the presumption of good faith into bad faith, the presumption of innocence into guilt, the presumption of regularity into irregularity. They need to fix that. And the Supreme Court needs to be conscious more about the governance implications of their decisions. Yes, that is not their concern. Right. That's true. But they need to know that when they declare something unconstitutional, there's real things that happen on the ground. We remember the MOA AD, which was declared unconstitutional by the court. And I would defend the right of the court to completely do that and say that the attacks against them on them was unjustified. But it's just a reality that when you do something like that, people die. In this case, if you do something like declaring a DAP unconstitutional, you do have an impact on government projects that are important, that can also be life-saving. So they need to be more conscious about that, while always deciding according to the law and deciding according to their deliberation. The reason why I love the Supreme Court, I will defend the Supreme Court, is because they're a deliberative body. You read the DAP decision and you know that they disagree, but they found a way to move forward. That I think it's an important point to make. The DAP decision is strange because it does not declare any law, any provision, any budgetary circular, any DBM, and any program unconstitutional. It doesn't. It actually gives guidance only. It just tells the government that these are the acts that you shouldn't be doing.
You can't do
it. It does not give any findings that any of the acts you have done actually violate this, right?
Okay.
But there was enough evidence to show that these acts were being done. But when will you find out about the acts, the programs that were really unconstitutional? Only when there's a comprehensive audit by the Commission on Audit, which will now be guided by this decision of the Supreme Court. In some extent, I mean, this is therefore not really it's an advisory opinion. I mean, we call it, which Supreme Court usually not do. But it was so important that they had to decide it now. But they could have decided to just wait until the facts were clearer, like an audit of the Commission audit would make that clearer at least. So it's these things. I mean, we need to be able to find as a society a way to make our institutions work together to achieve that common end that the president says. He wants, which is the good of the people, and asking the Supreme Court to use their legal acumen for the good of the people, and asking the legislature to do the same thing. But one thing I'm sure, part of doing good for the people is to obey the Supreme Court once it makes its decision. Because if you don't, everyone It's the ultimate wang-wang, di ba?
Yeah.
Now, when you say, I will not obey because I'm right. And, you know, I'm not saying the president said that, because the president is filing a motion for reconsideration. But down the road, I mean, I can just see people misusing the words of the president. And not obeying the law, and not obeying, I mean, in any court, any lawful order, because I'm right. That's problematic, I think, for society. So bottom line, we need to do that while still trying to solve our problems.
Okay, thank you very much, Dean Tony. We've been talking to Dean Tony Lavinia of the Ateneo School of Government on the Disbursement Acceleration Program and the contradicting pronouncements from the President and also the pronouncements of the Supreme Court. Thank you for joining us.